everyone. I didn't check in with my fellow co-panelists, but I thought I would start off by just saying your names and asking each one of you to introduce yourself. We have an amazing panel today for you to talk about how to train your lawyer. I am Shannon O'Loughlin, a citizen of the Choctaw Nation of Oklahoma, and I am a lawyer. And even as an Indigenous person, I have been well trained by the tribes that I work with. To my this way, whichever this way is, I see Judith Shapiro.
Hi, you still have to train this lawyer in unmuting, but hi, my name is Judith Shapiro. I'm a lawyer in DC. I've been working with tribes and tribal interests for about 36 years, and I'm still learning how to do it right. It is trying to get the language right, trying to get the listening right, and my code for all of this is shut up and listen. You'll hear more about that later.
And another lawyer here with us today is Nikki Ducheneaux.
Hi, good afternoon, everybody. Thanks so much for having me here. My name is Nikki Ducheneaux. I'm an enrolled member of the Cheyenne River Sioux tribe, but I also come from the Confederated Salish and Kootenai tribes. I'm a founder and partner at Big Fire Law and Policy Group, and we are a 100% Native owned and majority Native woman owned law firm. Which we're real proud of, but I'm the chair of our litigation practice group, and I represent tribes across the country in various fights that they get into with this, that, or the other one, good fights, which we love. And I'm real lucky to, in the past couple of years, have worked with Judy Shapiro on some of those important fights, but they include ones that are in the area of cultural heritage, which we'll talk about today. So I'm just very happy to be here.
And the most important person in this conversation and in this Brady Bunch two-dimensional box thing that we're existing in right now is Ms. Ernestine Berry.
Thank you, Shannon. I don't think I've ever been introduced just that way. But my name is Ernestine Berry. I'm the director of the John Hare Cultural Center and Museum in Tahlequah, Oklahoma. I am not an attorney, but I am honored to be here with the three distinguished attorneys, and I'm pleased also that I'm here to talk about my people and talk about the history and to help lawyers understand who we are. And we have been through this several times of teaching various attorneys about who we are, and it's a privilege to be here with you.
Wonderful, and absolutely an interesting when it comes to issues of cultural heritage and sacred places, where lawyers are really necessary to a lot of the work that happens. It becomes even more important that tribes and the culture keepers and elders and other cultural heritage practitioners and tribes work well together. So, Judy, did we start with Ernestine? Okay, Ernestine, I'm going to turn it over to you.
Okay, now how do I, can you see this?
If you're trying to share a screen, no, we can't see it.
Okay, how do I go about doing that?
There's a little button with an arrow pointing up at the bottom of your screen where the speaker.
Okay, yeah, okay. Well, select the file, okay.
It should be just like Zoom. Is it working? Okay, there you go.
Okay. Is it full screen? Do I go to full screen?
It's perfect.
Okay.
Anyone can choose to go to full screen.
Okay.
on their own.
Okay. The United Choctaw Band is located in Tahlequah, Oklahoma, and of course the Heritage Center, the United Choctaw Band Cultural Center, is located there, and we oftentimes have had to go through the process of training attorneys, as Judy well knows, and we know our history and we try to share our history, but many times the attorneys don't understand. They think they know what the history is, but a lot of times we have been able to share with them things that they don't understand and have never heard before. So Judy's former law firm was engaged to help us with our claim of successor in interest to the Cherokee Nation. The Choctaws, the Chickasaws, and the Cherokees had filed a claim regarding the ownership of the Arkansas Riverbed in Oklahoma, and we, as also Cherokees, wanted to make a claim to enter into that case as well. And we engaged Judy's law firm, and she happened to be the one who got our case, and she got to research the case, and we went there and we talked to the attorneys who were there, and they began to kind of look at us like they didn't know what we were saying. And so we told them what we knew, and they were very skeptical about it. But after Judy did the research and she began to realize that we were exactly who we said we were, and she filed a brief regarding our succession interest to the Cherokee Nation. And as no surprise, she did win that case. So that was something. And she says it was terrible. Well, she didn't really physically roll her eyes, but that attitude was there when we were telling the story. And so I want to just talk a little bit about the Catawbas and the Cherokees. The Catawbas are Cherokee, or we like to say the Cherokees are Catawba because that name came first. And that name was sacred to the traditional people, and so it has kind of stuck with us over the centuries. The Catawbas began to migrate west in the late 1790s across the Mississippi River into the Arkansas Territory before it was ever the Arkansas Territory. At that time, it was, I believe, claimed by Spain, and then it went to France, and then the United States bought it in 1803. In 1817, we got a reservation through a treaty in the Arkansas Territory. And then in 1828, because of some of the conflicts that were beginning to happen in the Arkansas Territory, we were kind of forced into the Indian Territory. And we became known as the Western Cherokees. We never really referred to ourselves as the Western Cherokees. That was a U.S. government designation for us to designate us that we were in the West, and the other ones were the Eastern. The Cherokee Nation at that time was called Eastern. The Cherokees decided they would fight legal battles in the courts of the United States trying to maintain their eastern homelands. But however, they were forced into the Indian Territory in 1838 over the Trail of Tears. And of course, by that time, they were known as the Cherokee Nation. The name Catawba is, as we pronounce it, Anikaduwagi Aniyawiya. That's kind of a mouthful, I guess, but that's it. It means that we are Catawba. We are of the mother town, Catawba, and we are the people, and it carries a connotation of being the native people. The Cherokees' name is they call it Salagi. We say Salagi. and we're not really sure of the name's origin. Some say it's Choctaw, and it means people of the cave country. Frank J. Boudinot, who was a member of the Cotulla Society, was the Cotulla attorney from 1898 until 1945 when he passed away. He helped us to organize in 1905, just before the termination of the Cherokee government. And we became, through the charter, the federal charter that we obtained, we became a political body at that time. And the Cotulla said, well, if the Cherokee government, which we were part of at that time, was terminated and there would be nobody to represent the people of the Cherokee people, the Cotulla people, there would just be nobody to represent. And so they decided to try to become a representative body, which they did. And they fought many cases in the land cases, especially in the Court of Claims. I can't really see my slide on the bottom. Okay. He knew who the Cotullans were because he was Cotulla. And he was asked at one time during a congressional hearing, who are the Cotullans? And he said, well, most of the Cotullans are the Western Cherokees. My mother also knew who we were, of course. When I was in high school, we had a little bit of history on the Indians and the Cherokees in particular. And of course, when you study about the Cherokees, you always know about the Trail of Tears. That's one thing that everybody knows if they know anything about the Cherokees. And so we learned a little bit about that. And when I went home that evening, I said, Mom, when did our people come over the Trail of Tears into Indian territory? And she said, oh, no, our people didn't come on the Trail of Tears. We were already here. We are old settlers. We are Cotullans. And that was just, she had never mentioned that to me before. And I'm so glad that I asked her that question because it gave her an opportunity to teach me some things about who I am. So I'm very grateful for that. She passed on in 2001, but I'm glad that she did at least share with me the heritage. Sequoyah was also a Western Cherokee. He came into the Arkansas Territory in 1818, and he worked on his syllabary while he was there. And much of the government documents and, of course, personal letters and things subsequent to 1821 were written in the syllabary of Sequoyah. And the institutions which we have visited collected a lot of those syllabary documents, and they're no longer available to us as Cotulla people. The John Hare Cultural Center and Museum was awarded a grant in 2016 from the Institute for Museum and Library Services. And we felt like we needed to collect a lot of the syllabary documents that were out there in various institutions. And so we made it a point to go to various of the institutions and collect those documents, or at least copies of them. Of course, as far as we know right now, we will never get the original documents back, but we were able to get the copies of those documents. Some of the places that we went were the Yale Beinecke, the Newberry Library, the University of Tulsa, the University of Oklahoma, and the National Archives in Washington, D.C. And we brought those papers back and translated them. Our language team translated them into English. This is one of the documents that we discovered at the Yale Beinecke. It's a story of Ugiwaleda, the great Cotulla warrior, and it tells about some of the battles that he fought when we came into the Arkansas Territory. It also helps to identify the Cotullans as Western Cherokees, which was something that we didn't have very much verification for that. But when we got the syllabary documents, we have several instances where they were called Cotullans. This document was from the University of Tulsa. It's an 1860 document that was written just prior to the American Civil War. And the Cotullans were afraid that during that war, were they to be dragged into it, as they always had been, every white war, that they were afraid that they would be killing each other. So they wrote out this Pledge of Unity, and they all pledged to unify in one body during the war if they were forced into it. The University of Tulsa had this document, and they had no idea what it was. They still don't have a clue because we haven't sent them the translation to it. But when I first came in and was director of the museum here, I felt that there was a need for us to collect Kituwa documents from the various institutions. I called Tulsa University and asked about getting copies of their documents. And the young man I talked to said, well, that will cost you $20 a page. And I said, really? Those are our documents. Why do we even have to pay anything for them? And he said, well, okay, I'll talk to my boss and I'll call you back. Well, the next day he did call me back, and he said, my boss said, well, we're sorry, we can't make any exceptions. They will cost you $20 a page. So we couldn't afford to do that, because I knew my sister and I had previously been there, and we saw lots of documents there that were written in syllabary. And so I knew that it was prohibitive. So about a year later, the boss man called me and said, do you have anybody there who can translate syllabary into English? And I said, yes, we do. But we're going to have copies of your documents. And he said, oh, okay, well, yeah, I think we can do that. So that was one victory for me. I felt really, really good about that. Okay, and this document is from the provisional period, actually from the reorganizational period, and it was written in 1939. It was the Constitution of the Provisional Government of the United Kituwa Band, and the handwritten note on the folder that it was in said, "This is a constitution of some sort." So they had no idea what it was really, except that it was some kind of a constitution. And, they keep these documents, but what good do they do anybody while they're sitting there in their files, filed away, and never anybody pulls them out. Nobody knows how to read them. They don't even know how to catalog them because they don't know what they are. And then at the Oklahoma University, we found the original copy of the 1925 Nighthawk Constitution. And we brought the copy. Well, actually, the library sent us an electronic copy of that document, and it's 32 pages long. We translated that into English, and I did send a copy of it to the Oklahoma University Western collection. Okay. These Kituwa documents and papers, they're really of no value to these institutions. Really, the only ones they're valuable to are the Kituwas and our lawyers. In case we need to use those, we need documentation. We've had lawyers come and will say, well, where are your documents? And for so long, we didn't really have any because our documents were kept by the secretaries of the tribe in their homes, and a lot of them became scattered and destroyed and whatnot, and put into institutions however they got there. And because they're really of no value to anybody except us, we really need to have, there's an undeniable, I think, need and right for the repatriation, not only of funerary remains and sacred objects, but also for our original documents. And with that, I thank you for listening and for your attention.
So I guess it's my turn, and I would like to fill in some blanks because I've been very fortunate to work with Ernie on and off, either as, professionally or as a friend for almost 20 years now. And she's mostly forgiven me, but occasionally not, for just not getting it the
That's
first
true.
time. Right? And sometimes I
All right.
still don't get it because, and here's part of the problem is that when you bring a lawyer into this kind of setting, lawyers are trained to go for the jugular with documents, with arguments, and with all that stuff. And as she's just told you, those documents weren't available to us 20 years ago. So what we had was an oral history, which is valid and correct and all of that. But it's the sort of thing that it's difficult to go into a forum saying, well, we know it because they told us. And it's painful. It's a painful thing. And I've had this experience a number of times. Like sometimes it's we know it because they told us, and sometimes we can't tell you because it's sacred and we're not permitted to tell you things. And so there is a problem of being a lawyer in the context of his Indian history matters and cultural matters and sacred matters, because not everything you need is accessible. But you have to learn to listen, because until you learn to listen, and as a lawyer, that's hard sometimes, you have to know to express your ignorance and admit your ignorance and sit back and listen to people who know their own community better than you ever will. And that's true, obviously true for those of us who are non-native, but it's also true for folks who are native, but from another community. I've had this experience of lawyers who want to parachute in and take control because after all, they're native and this is how we do it in their community. And that doesn't translate either. So in the context of what the history that you just heard, and it was abbreviated and, it's hard to do it in that speed. The problem that I had, and, I was 20 years into practice. I'd been doing Indian law for long enough that I thought I knew how to approach a problem. And part of the way that I approached the problem was to read in advance and to read context. But if you read context in this community, what you read is Cherokee Nation history, and it's not the same. And it's not the same, particularly when viewed from the Kituwa perspective, who were there either part of it or alongside or fighting for survival or fighting against erasure for all of that time. And if you listen to the stories from Kituwa, it makes you doubt what you've read. And you're a lawyer. What you know is what you read. So let's talk about some of those documents. And we've actually been discussing this the last few weeks, because I would argue that the documents that are sequestered in these museums and libraries are objects of cultural patrimony. These are the foundational documents of the Kituwa band. And they are held by people who don't know what they are, have no particular use for them except for possession. And that's a colonial position, extraordinarily so. And here's the Kituwa band, which 20 years ago, had we had those documents, had we had this access to the documents, we could have made our case much more easily, because remember, we're in a forum that is looking for our credibility. And we could have said, well, of course they're a separate governmental entity, and here's the proof. Here is this constitution, here is this treaty, here is this, here's that. And we had only a small fraction of that. And the story that we were talking just before that Ernie left out is that when she went to this compendium of documents in the syllabary, two of the documents turned out to be letters written by her great-grandmother describing a visit to her nephew. A nephew, was it? Somebody, a family member. But it was in the syllabary. And it was just as opaque as the Constitution of the Kituwa band. And what in the world, how is that belonging in this institution? How is that not something that is richer just in its existence in the community it came from? How are these things separated from the community? So I'm saying all of this because in the context of where information is and where it isn't, this is what you have to train your lawyers to understand. That often when you parachute in under time pressure, going into a forum that is every bit as ignorant as you are and possibly more so, you have to be able to translate the absence of information in a way that you can still be persuasive. And that's often the hardest thing to do as a lawyer. And this is where we had those problems. And there was some eye rolling because, if Ernie can say to me, well, my mother told me that, and I'm thinking, great, how do I tell the judge that? How do I say, I know this because Ernie told me? But that's often the way it is. I got lectured a couple hours ago by another client who said, you guys, you lawyers, you don't understand that truth is what it is. And often the only source of our truth is what we got from our grandmother. And when my grandma told me things, and she was born in 18 something, and she got the information from her grandma, who are you to tell me that's not appropriate information? And so I get scolded a lot, and I try to learn every time. And I think it's probably the only reason I'm still in this business is I've learned to listen. But when you are engaging lawyers from outside the community or even outside the understanding of this, you have to know that they are at best mouthpieces. They are at best your agents, and don't let them bully you. Don't let them substitute anything for your truth. And you're going to have to browbeat them sometimes to say, this is the reality that we're trying to protect. And please understand that this is where we're coming from. And if you're going to speak for us, you have to do your best to understand why this is important to us. And that importance is really the only way you can convey a winning argument. Because if you're a lawyer and you're representing someone, if you present a dry argument saying, well, we want these papers because they're ours. No, we want these papers because they're ours, because they reflect our history, because it is important for us to have our history. It is important for us, for our children to know where we come from. All of these things are the fight against erasure in a larger world. And it's more than just going in and saying we want our rights under this particular agreement. We want to validate who we are. We want to be seen. And if you, the lawyer, can't see it, how can you possibly communicate it? And I think that's possibly the most important thing. One thing that Ernestine did not tell you, because she's being very modest, is she is the founding director of this museum. And the reason she's the founding director of this museum is because she understood how important it was to recover and collect the documents in the tribe's history in a place where it had never been done before. And that I think she rightly understood that not having that history in one place was handicapping bringing the tribe into the future and maintaining its foundation in the present. So shortly after we scrapped on doing this work, she had the vision and the persistence to go and get herself trained in museum management and archive maintenance, get a degree in that, get all the grants, build the museum, and do this very righteous work of making sure this history was present for her tribe. So that's sort of where we have overlapped over the years. And I guess that's the story I want to say. I learned a lot from working with her. I still learn a lot from working with her and talking. And this is the kind of thing that people need to understand. When you hire a lawyer, it's still your matter. It's still your history. It's still your heart. And if the lawyer is not listening, you need to tell them, sit down and shut up. Shut up and listen. Because there's truth to be heard, and you're not going to hear it if you're still talking. Nikki, you want to go next?
Yeah, thank you. And thank you, Ernestine and Judy, for sharing that story. It's so important. And I just want to echo what you guys said. So one of the cases that I have been really honored to work on over the past 5 years now, if you can believe it, is the Dakota Access Pipeline litigation, which did have a lot of, many of the issues we were working on wasn't not just water resources, but also cultural heritage. That has been one of those cases where it really brought into sharp focus for me how this listening process really needs to be observed by attorneys, because it can have a substantive effect on your litigation. And so just in the most general terms, the the Dakota Access Pipeline litigation was an emergency. There were bulldozers poised to begin, plowing up our sacred sites and ancient things that had not been properly evaluated and where there had not been good consultation. And so attorneys rushed into filing the lawsuit and did an excellent job with the briefing and with the research. And we're very much on point. But I think a lot, in those very early stages of that litigation, there was a lack of that listening. The attorneys, felt that they understood the legal issues and that they had a basic sense of the facts, but didn't understand exactly how the tribe perceived their cultural heritage. And, so not to get too specific, but it did result in a bizarre moment in one of the first hearings where the court was trying to define, what is the space where Lakota cultural heritage should be protected under these laws. And of course, the answer was our 1851 treaty territory. But everybody who was making that argument was not familiar with our 1851 treaty, and maybe would not have been familiar with it in the context of all of the things that they researched for that litigation. But if every attorney had sat down and taken the time to listen to any Lakota person, they would say, oh my God, what's the most important thing to us? It's our 1851 and our 1868 treaty. But, from my perspective as a Native person, some of that listening comes naturally. Because, in addition to being a lawyer, I'm a Sioux Indian and a Salish Indian, and raised by Sioux and Salish parents and grandparents and aunts and uncles. And I grew up listening to my elders. So if you're litigating a case like DAPL or another one where cultural heritage is at issue, you're going to be dealing with your tribal historic preservation officer. Your tribal historic preservation officer, is probably a traditional person. Who has been raised with these traditional worldview and traditional way of communicating information. So as I said, some of that listening process comes naturally to me because I have spent time with traditional people my whole life. And I know that, sometimes older traditional people, take a different path to giving you a story or information than maybe, like Tom Brokaw on the news or whoever the newscaster is now. It maybe does not follow a straight line, and it maybe does take a long time to get to where you're going. And unfortunately for lawyers, most lawyers are like, okay, let's get to the point, let's get to this information. I'm billing by the hour or what have you. And it's a tendency of attorneys to, direct the conversation, take it where they think it needs to go, and do it in the shortest amount of time possible. When you are dealing with tribal cultural heritage, that's exactly the wrong thing to do. As Judy and Ernestine were saying, you really have to listen, because, even, and this was told to me by a traditional Lakota speaker, that some of the way that we convey information is actually tied to the language itself. And so communicating something that's very specific about our religious beliefs or our cultural property, for somebody that's coming from that frame of mind, they may be even translating it from their native language into English as they're doing it, which, creates another, sort of a barrier, not a barrier, but maybe a little bit of a challenge for somebody who's got a real type A personality trying to get that information. So, those things are all really important. And as Ernestine and Judy were saying, another thing that attorneys sometimes do not understand is that when we're talking about cultural properties and religious rights and sacred sites and things of that nature, sometimes we're talking about things that have been, we're illegal, within the lifetime of some of the people that you're talking to, religious practices, things that, our people learned to keep secret and private because of a, like a threat against our religious freedom, or things that people keep secret and private because they are so sacred and closely held. And, an attorney who is investigating those matters needs to know where to draw the line. Needs to know, make the person feel safe, understand what things they can and cannot share with the court in a declaration, and things like that. The other, I'm kind of rambling a little bit, but the other issue is that, there has been a culture of paternalism, not just in, our government or our mainstream culture, but even in the practice of federal Indian law. I think, ongoing to this day, I have watched many Indian law attorneys who have a paternalistic attitude toward their client. And this includes Native and non-Native attorneys who show up and say, well, I'm the big lawyer and I know what's best. And then will dictate to the client, again, not listening to what they have to say. And again, that's exactly the wrong way to go about it. Because you have to have, like a good attorney that really cares about advocating for your tribe and advocating for your issue, again, has to see, like your THPO as the expert. They have to see your tribal council and your tribal chairperson as the ultimate sovereign, as the authority, and as grown adults. I think that there are some people to this day and age who still look at Indian people and say, well, you're just, I know best, I'm going to tell you what to do. And, for some of us who are, Indian attorneys who come from tribal communities, it's not difficult for us to say, oh my gosh, this person is our authority and the leader of our sovereign government, because, we come from those communities. I think there are a lot, obviously non-natives have that perspective too, but it is so important. It is just so important to honor and respect the sovereignty of the government that you're representing. But again, it is a process of learning. It is a process of listening, and any attorney can do it, whether Indian or non-Indian, provided they come to the situation with humility, and with the willingness to sit and be patient and learn their clients' culture, learn their clients' history, learn how they communicate. And then after that learning process, to have the humility and the patience to sit there and actually listen to what their client has to say, and to let the client guide the attorney in the facts that they're presenting, guide the attorney in the legal decisions that they're making, and to do that in a good way with integrity and humility. And as I said, anybody can learn it. But if you, people who are, THPOs and individuals working in your tribal community, if you find that your attorney doesn't do that, you need to stand up to that person, because what's very unfortunate is that, Indian law cases go to federal court and they get litigated, and then they go up to the U.S. Supreme Court. And, unlike when you're talking about some white person's contract or, some business deal, these are our hard fought treaty rights that our ancestors reserved for us. And, once you get a decision from even a lower level federal court on that treaty, that lasts forever. And so, the kind of care that an Indian law practitioner has to take with your cultural heritage, with your treaties, it has to, more so even than other attorneys, I would say. And if you don't see that happening, stand up to them, because it's, I see it in places somebody wants to make a name for themselves litigating a famous case or a treaty. That's not, they have the wrong perspective. That case is not about them. It's about you, and it's about your future generations. So that was my rant. Sorry, I kind of ranted on that.
No, that was awesome, Nikki. I can listen to you all day. Thank you. Thank you so much for sharing that. So I want to talk a little bit about being an attorney in this area of Native American graves protection and repatriation, because I think lawyers have a real specific role that can help support the protection of cultural heritage that I don't know how much we're taking advantage what lawyers can do for us in this space. So let me tell you a little bit of my own story. Is that when I was a fairly young attorney, about 5 years in, moved to New York State and had the wonderful opportunity of working with the Haudenosaunee Confederacy and the traditional nations of the Confederacy. And through that process, they made it very clear that repatriation was a high priority. And I did a lot of listening and taking direction as a young attorney about those issues. And what I found that tribes were actually following NAGPRA and attempting to work with museums to push through cultural affiliation determinations and repatriation. And that oftentimes were met with delay, obfuscation, and just, ignoring tribal practitioners. And then, of course, in our tribal governments, often we change administration every 1 year, every 2 year, every 3 year, every 4 year, or even in those institutions, tenure of people will change and put further delay on those issues. So as I worked with them, I got permission to send an attorney letter. And if you've ever received an attorney letter, it's a little bit intimidating if you're an individual. But what we found is sending some of these museums the attorney letter demanding repatriation and return actually shifted the dynamics of that consultation and negotiation towards repatriation that hadn't happened before. And it was very, as a young attorney, it was very, it kind of hurt my heart that here we have a piece of legislation that was developed for the benefit of Indian tribes and lineal descendants, and was being completely ignored until an attorney stepped in the room. But that's also where I found that also there was a lot of power there that I could have as an individual attorney to move and shift things in another direction for my client, which is exactly what we want, right? And when you are led by the tribe to do this work, it can have amazing effects. And what I also learned, as you kind of develop as an attorney in your practice, especially if you are an Indigenous person and come from particular cultural norms, you begin to connect what it is you're doing with the different roles that are in your cultural societies. So oftentimes different tribes will have the people who are involved in war and conflict are separate than the people who deal with peace, are the people who deal with graves, or the people are dying, or the people who deal with food, and everyone has their own role in their communities and in their nation. And I found working with the Haudenosaunee Confederacy that I had a place that helped to keep the conflict away from the things that were occurring that were sacred and needed to be protected, so that those elders and traditional people could continue to do their prayers and their good thoughts to bring ancestors home. Well, I could be separate from that and work to deal with the conflict and the Western ideology that was interfering with the restoration of the ancestors coming home. So that, what I'm saying is that attorneys have an important role in this work to help maintain and keep the conflict separate from the important spiritual things that are happening with this work. And there's so much that I'd love to say about being an attorney. I'm going to switch though to the not so good stuff about being an attorney, is that I've also had the opportunity to work with as like a manager of various projects that occur in Indian country. And so I've gotten to see what attorneys' bills look like and what their work product looks like. And oftentimes these are issues that many people who are not attorneys don't quite know how to manage. And I think it's so important for tribal government and the staff and people who are working with the attorneys, make sure they developed clear and transparent relationships with their attorney so that they can ask those specific questions about the billing if there's something that they don't understand. And that potentially maybe there's other ways of paying for an attorney besides an hourly rate that are available to make it a better option for the tribe who so needs an attorney. There are not to exceed fees. There are fixed fees. There are other opportunities to change to a fee that's more manageable than sometimes what an hourly rate can do to the budget of your nation. So fees and fee structuring are one of those things you need to understand about working with your attorney. And I think tribal in-house attorneys are the best attorneys out there. I always enjoyed working in-house with a tribe because, you're on the ground and you understand what's going on with the issues and needs of a particular tribe in a much different way than an outside attorney who is separate from. So that's why you'll see the good attorneys like Judy and Nikki. They are on the ground with their client as much as possible. Those are the good attorneys that you have to watch out for. But I often tell people, your attorney, it's just like a bag of chips. If you don't like that flavor of chip, there's a plenty out there. Some with ridges, some with sour cream. There's all sorts of dip out there too. So, if an attorney is not working for you, then I'm sure there's one that will work better. But with NAGPRA and cultural heritage, I think involving attorneys in this law that we have to work through is extremely important. And I think it's more so than any archaeology or other types of anthropological or other research involved in this, because it is a simple legal process that tribes and museums need to walk through together to achieve success. I'm going to stop there. And let's open this up for discussion. I want to remind people that there's a Q&A where you can put your questions, or you can raise your hand and we can bring you up onto the scene with us with either your audio or your video as well. So please feel free to ask questions of anyone here. And while we're waiting for that to happen, I've got some questions here I could ask. How have you all? I'm sorry, is someone saying something? Oh, I heard an echo. Sorry about that. How can Native representation in legal practice support and protect Indigenous rights and cultural heritage protection? So So I guess this is a question about diversity in legal practice, and hiring a Native attorney and how that can be helpful in, or not maybe, in cultural heritage protection issues. Does anyone have an opinion? What do you think, Ernestine? Would you rather hire an Indian lawyer, or does it matter to you? Oh, you're on mute. There you go.
I think it matters less whether they are an Indian or not than if they care. If they really are sincere and really care and will listen, and like you said, in our tradition, you don't get in a hurry when you talk. You don't just come in and start talking and then expect immediate responses. Our people are not that way. They're very reflective. They sit and they consider the answers, and they consider the conversation, what's being said. They have to think about it for a while, and then when they do think about it, they will come up with probably some answers and suggestions that may surprise the attorney. But the attorney cannot be in a hurry. If they get in a hurry, our people would not engage with those attorneys that would get in a hurry and expect them to just speak up and shoot back an answer right now.
And that's why maybe hourly rates aren't the best when you go to hire an attorney for an Indian law case, right?
It could be, yes.
Yeah, I will echo that. Like Judy Shapiro is, I think, one amazing example of a non-Indian attorney who is really one of the best advocates for tribes that there is. Really cares about our community, really approaches what we are doing with humility. And there are lots of those people out there, lots of great non-Indian attorneys that practice in federal Indian law. There's some other ones, and I guess you just have to be, watch out for them. I think about those ones that get into our community and get into this practice of law for Indian people that don't seemingly care about those things, about approaching the practice in a humble way and being there to serve our community. You think, well, why are you doing this in the first place? What are you doing here? Go be in some other field of law or something. I don't know. But it really does take, as I said, it just, it takes a willingness to learn. And as Judy pointed out, the first time we were kind of prepping this panel, and as she said in her remarks earlier, sometimes a Native attorney comes to a representation or comes to an issue and thinks they know everything because they're a Sioux Indian and all, here they are on a Katua issue. Totally different. You have to know what you don't know. And one of the things my mom always says, which is kind of amusing to me, she says, if you've been to one Indian reservation, you've been to one Indian reservation. So I think that's like that about all tribes. Like you just have to, you have to take each one as brand new.
Well, having heard that, and thanks, Nikki, I want to take a little bit of the other side. Sort of a generation ago and a little bit more, when I first got into this business, there were not a lot of young Indian lawyers. It was a new field that was exploding when I came onto it in anticipation and in the aftermath of Indian gaming. And so all these people were coming in and saying, oh, there's money to be made. And that's one of the answers for how there got to be a lot of people in that area, that and the earlier Indian land claims where there was money to be made. But with that Indian gaming money, there came to be more and more Native kids going to school and going to law school. And the law firm I was in there, where I served briefly as hiring partner, possibly to everyone's chagrin, I had a very strong Indian preference. And I used to go to conferences and find the very best young Native lawyers I could and set up to mentor as many of them as I could, because I feel that that's who belongs in this field. And I see myself as a little bit of an albatross, because there are more and more really super duper capable Native lawyers like Nikki and her whole firm that I'm so pleased to be associated with. And even though those lawyers may not be specific to every tribe they represent, the starting line is enormously advanced, because you don't have to say, and this is the difference, this is what history is generally in this country, this is what colonization means. Those are folks who are in it, not always, but who are in it knowing that this is preparing the future for the generations after them. And so, in my own self-interest, I'll say, you don't always have to hire an Indian lawyer, but it is good that that possibility exists. And for the future, it is important that that possibility exists. That is a reversal of the paternalistic treatment, and it's an important thing to have around. Shannon, you're muted.
Of course. I'm going to bring up a question on stage that I think is a really good question. And Kristen is asking, for agencies, we may often have a designated environmental attorney who may not have specific NAGPRA training or no training at all, which we often find on NAGPRA issues. What are your thoughts on how to improve their understanding to support your agency NAGPRA efforts? Well, first of all, they should call the Association on American Indian Affairs. We'd be happy to train them, or the National NAGPRA Program, or Judy or Nikki. There are some wonderful, there's a few of us, a handful of attorneys who are really familiar with NAGPRA and other repatriation and common law theft issues, looking at matters of repatriation. Anyone else want to add to that?
I do. So environmental law is a subspecialty of being a lawyer. I don't practice environmental law. I mean, I may dabble in the edges, but if I get a case that has environmental law involved, I find somebody who knows how to do it, and I step back. And someone who is hired to do specifically environmental law doesn't have the set of skills and knowledge that's important, and ought to have somebody associated. I think saying we've got an environmental lawyer, so we're going to put the birds, the bees, and the Indians all in one box is kind of not what we should be doing.
I want to make a point that Kristen is from the Army National Guard. And Kristen, there's other attorneys in the federal world that do have expertise with NAGPRA, and I look to Department of Interior solicitor attorneys that are in their portfolio. They specifically have NAGPRA expertise and experience, and help to support those issues within the Department of the Interior. So perhaps that's one way that an attorney from another agency can gain the expertise in addition to the various training that's going on. But you've got to go get the expert, right? Let me look at some other questions. So NAGPRA practitioners in museums and universities don't always have the ability to consult with Native attorneys and have to work with their institution's Office of Counsel, which often have very little background in cultural law and have never heard, of NAGPRA. For example, in my 3 years as NAGPRA coordinator, I've worked with 5 attorneys, each with different opinions and guidance on NAGPRA. Do you think more progress can be made by working with institutional compliance officers instead of attorneys. So remember that you can also raise your hand if you have a long question. Happy to discuss that. So the question is, how do you best work with attorneys when you're getting differing opinions on how to do NAGPRA? How do you train those lawyers?
How about you put them in meetings with the lawyers for the tribes that are making the request? So that if the people who are advising you don't have the education and don't have the ability to go outside, then since it's supposed to be, what is that word? Working together process? There's a word, which I'm lost. Why not work together? It doesn't have to be adversarial. And let the people who know how to point you in the right direction, point you in the right direction. And that becomes a process whereby your inexperienced lawyers can look things up and get educated. This doesn't have to be a fight. This can be a non-adversarial ability to resolve things the way they have to be resolved. And if you're not getting that advice, meet with the people who think that they have a right to do it and find out why they think they have a right to do it.
That's the problem with, so Jacqueline's coming to us from a university with her question. So oftentimes institutions and their attorneys, or once the institution gets an attorney involved in any kind of question, it immediately becomes adversarial. And so oftentimes, unfortunately, attorneys are trained to work inside that box of holding on to the position of the institution, whatever that is. And so when you engage the attorneys, they're trying to protect the institution and the institution's interests. So that's why it is important in the leadership of that organization to have set and clear policies about how it's going to handle NAGPRA that the attorney needs to comply with, because they're representing the institution and that institution as a whole. They're not representing their own opinion about how they think NAGPRA should be resolved. So I would, Jacqueline, I would say go to the leadership of that institution who makes the policies and make sure that they are they're clear and that they're done in consultation with tribes, hopefully. Feel free to jump in, Judy or Nikki. Let me, as I look through the questions here. Here's one from Veronica. Let me show this on stage. Speaking of the Army, she says, is this an appropriate time to speak to the Army's claim that it doesn't need to implement NAGPRA at Carlisle Indian School? I don't know. Is this a good time to talk about that? Anybody?
I'm in favor. And this is something that you and I included in the comments on the revised NAGPRA regulations, that the statute itself, notwithstanding the Army's protests, expressly covers every agency of the United States government, and the Army is the agency of the United States government. I know because I looked it up. So if the Army is an agency of the United States government, then it is bound by NAGPRA, and it doesn't get to say we're going to use our own rules. We're not going to follow NAGPRA. I mean, maybe they could say we're going to follow our own rules, but once they say we're not bound by NAGPRA, they're wide open to a really wonderful and juicy attack. And so, to the extent that the rules that govern repatriation are set by NAGPRA and implemented by the Interior Department, then those rules govern, and the Army doesn't get to say, now we're keeping them because we decided we want to keep them, or now you have to jump through these hoops because we decided those are the hoops that we're setting up. And so I think, and I'm hoping that there is an opportunity brewing to fight back against the Army, particularly holding on to the ancestors who are stuck at Carlisle.
And I think, I would slightly go back to somebody's previous question about agencies. This is more of a macro observation, but, the Army, of course, and the Army Corps of Engineers as a separate subsection of the Army is always a tough agency to deal with, but so are all of them. I mean, even the BIA, which is our agency, is tough for us to work with. But the thing, of course, that makes BIA so great for us and Interior great for us when it is not only that it has a specific responsibility to us, but that there are lots of Indians there. And when you're in other agencies, you're talking about the Army or the Army Corps, the Department of Agriculture, or other agencies, Department of Transportation, that deal with tribes and deal with cultural heritage and deal with our issues. It would be so nice if there were Indians in those agencies that were administering programs that related to us and touched us. And one thing that I'm seeing in the Biden administration is that the Biden administration has appointed Indians in sort of non-traditional Indian spaces, at the, Bureau of Land Management, Department of Agriculture. Like, these people are not just, these Indians with Indian country experience are not just over in the BIA. They are in, the main part of that agency administering laws that have to do with white people as well as Indian people. And you really can see it right now in Department of Agriculture. The general counsel there is a Native person. They have a great tribal liaison. And then I'm always bragging on my first cousin, Zach Ducheneaux, who is the director of the Farm Service Administration. But that's not a traditional space for us. And the more we have our people in those places where they're administering our projects, even though it's not traditional Indian country, the better for us. I mean, it's just a representation thing. And of course, even at local levels, if you can have your Indians on their Public Utilities Commission in places in academia and this, that, and the other thing. So that's one thing I would say about that.
I want to add a little bit to it that until we reach that nirvana of having appropriate representation, we need to have a way of communicating things that are normally said softly, so that what I saw in the recent repatriations from Carlisle, what frustrated me as a lawyer is that I wanted to see more pushback. I wanted to see someone say to the Army, "How dare you?" And that's my reflex is, I want to go in and go for the kill there. But what doesn't work there is that where lawyers might see this as a battle to be had, the subject matter is painful and quiet and not necessarily to be spoken aloud. And maybe there are times when it can't be spoken about, and maybe there are ways that it can't be spoken about. And the people who are making the decisions at the Army are looking and saying, the best I can say to them about them is, this is how we deal with people who are buried. Except when the Army is dealing with people who are buried, they're dealing with adults who were part of a military operation, and maybe they didn't survive, and maybe something happened. But we're talking about children who were taken captive. And we're talking about generations that have been separated from those children, and it's loaded in a way that the Army doesn't understand. And I think that I don't know, this is the part where I see myself as a translator in some ways and trying to find a way to be a more effective mouthpiece, that these issues, this difficulty, there has to be an education of those decision makers separate and apart from the decision making. They have to hear from some of the relatives the kind of pain that is caused, not as part of advocacy for stop doing this to us, but as an understanding of what the situation is. And I don't know, as I'm saying this, what is the best way to set that up. But I think that there needs to be a better educational effort generally of the things that are difficult to say out loud. And I say this having been watching most of this conference, and I learn more every hour. of what I don't understand. And I'm open to it. Those guys aren't. We have to build some bridges to people to make them understand what the stakes are.
Yeah, and frankly, I believe NAGPRA applies currently. In NAGPRA's current regulations could apply to repatriate those children from their graves to return them home. The Army Corps' position, which they argue is from the Thorpe case, if you all remember, which was a case in Pennsylvania that came out of Pennsylvania where there was a city named after Thorpe, and he was buried there. One of his wives allowed him to be buried there against the wishes of his children and others. A case was brought under NAGPRA, under the repatriation provisions of NAGPRA. And the repatriation provisions, the judge, it went into the Third Circuit, right? That's the circuit with Pennsylvania, or is it the Fifth Circuit? Third Circuit. It went to the Third Circuit, so it's a case that only applies to Third Circuit states, such as Pennsylvania, which is where Carlisle is. But the judge held that, well, this is not why NAGPRA was enacted. NAGPRA was enacted because there was a horrendous removal of graves from of Native American people, and it provided a process to return those graves. That's not what's going on here. This is a family issue. This is not a NAGPRA issue. So he distinguished it there by talking about the egregious nature of why NAGPRA was passed. And then he also said, and so because of that, the city can't be considered a museum, which was kind of a weird thing to say, because that goes against NAGPRA's express language. So it was just kind of this odd finding. But he was only talking about the repatriation provisions of NAGPRA. And so what the association attempted to educate the Army Corps about was what we're talking about are the graves protection provisions of NAGPRA, Section 3 of NAGPRA, that allows an excavation to be done, a planned excavation to be done, and is very broad about that. So it could absolutely include the returning of children back home from Carlisle. But anyway, I wanted to move us to a point about back to the importance of attorneys in cultural heritage protection. And what I found most intriguing is many of us, when we talk about repatriation, we seem to be a little bit stuck with NAGPRA. And we're also stuck maybe in ARPA, the Archaeological Resources Protection Act. And we don't seem to talk about that there's other laws, federal and state laws, that may apply to the theft of our cultural heritage items. And in addition, there's also tribal laws and even tribal constitutions that apply to the protection of our cultural heritage. There are many tribes in their laws that have statements that the tribe maintains jurisdiction over their cultural heritage wherever it may be. And I use that as an example from the Lummi Constitution. There's some powerful tribal laws, as well as other state and federal laws that can support repatriation efforts where NAGPRA and ARPA may not apply. And that's where we really need creative lawyers to think about what is outside of this box that we generally consider NAGPRA. have Judy and Nikki and Ernestine, have you all ever explored anything outside of NAGPRA or ARPA that could apply in these situations? Or
So I had a thought listening to Dallin maybe the other day talking about tribes exercising sovereignty in order to better recover items, and started thinking, well, what would that look like? And some solution to the oral history problem is what comes to my mind. That if a lawyer is coming in and saying, well, so-and-so's grandma said, maybe that has greater force if there is an intermediate tribunal within the tribe that affirms that to be what the tribe accepts. That's the tribe's history. And maybe you have a tribunal established just for that purpose, or as I've experienced in Nikki's tribe, when the Supreme Court sits, it sits with 2 law professors and 1 traditional judge. And the traditional judge is there when matters come up which are outside the scope of what law professors do, who are not tribal members. And if we had the availability of a traditional judge to make this determination so that when you show up saying, this is our cultural patrimony, these are items that should never have been severed from our community, and your purported bill of sale is spurious because that person was not a rightful representative. If you are able to go in there with a statement that has the power of the tribe's sovereignty with you, maybe that's one of the ways to bolster the case.
Nikki and yeah, go ahead.
If someone wanted to do that, Judy, they would need to know who that person was from whom that institution acquired whatever it was. And how would they find that out? Are the say the universities, their libraries and so forth, are they compelled to tell you that information in any way, or can they just hold it to themselves?
Well, my understanding is that for items that should not have been severed, right? The only way they can claim, if we can establish that an item is one of cultural patrimony, let's say you're looking to a constitution. If we can establish with a reasonable certainty that's an item of cultural patrimony that is fundamental to the founding of the government, it should never have been severed any more than anybody should go to the National Archives and steal the Constitution from there. Then the only reason that is not subject to repatriation is if the institution has a right of possession as defined in the statute. The right of possession as defined in the statute means that they have to prove it. They have the burden. Once you establish that it is subject to repatriation, they can say, but we got it fair and square. And you can say to them, prove it. They can't just say, we got it. They have to say what their right is under the law. And the regs should be clear on that. And that's something we've been discussing also. But they don't get to keep it just because they think, they stole it from somebody. If someone happened to have possession of it and said, I'd rather have the money than these documents, and that person did not have the right to disperse those documents because those were tribal documents, not personal. And that's going to be the critical issue. Those are tribal documents. Those are founding documents of a nation. Then they have to tell you why they think they got it, and you get to tell them why that person didn't have the right to give it away. Does that sound right, Shannon?
Yeah, under NAGPRA, yes. But what you're also describing is a common law act of theft.
Yeah.
So if I go in and I steal from the National Archives something, or even from the library, I go into the Library of Congress and and put something in my bag and they check and they don't find it and I go off with it. You know, I've stolen National Archives material. It's considered the property of the nation, right? It's national material. That's theft. Now, they may never know it was me. They may just find it's missing. But if I come back 50 years from now, or my son Wolfgang tries to sell it on eBay 50 years from now, he will not have good title. He cannot pass good title. A thief cannot pass good title to anyone, even if they purchase it, even 50 years down the road, right? And so at that point, then the National Archives would have notice, oh my gosh, those are our documents, and they would seek the return of those documents. That's an option in the common law that that is outside of NAGPRA that has potential.
And this is a little bit more complicated because in the case of the Cotulla documents, there wasn't an archive then. It was in the hands and the possession of whoever was serving in tribal office, and maybe stayed there. Maybe it stayed out in the garage. Maybe it stayed in the attic. But their possession was not personal possession. Their possession was limited to as a concomitant of government service. And so when that service ended, maybe they're custodians in some way, but not by right of ownership. And so Cotulla can reach out and say, yeah, I know it was in your attic, but that wasn't yours to sell. That's conversion under the law. You take something which you might have possession of, but you don't own, and then you sell it or you give it away. That's not conveying good title either.
Mm-hmm. Right. So there's a lot of opportunities in the law that beyond NAGPRA that we need legal eyes to look at and explore. Someone mentioned the National Stolen Property Act. That's also a federal law that could potentially apply, but it has monetary restrictions. So something has to be valued at a certain monetary number before that will apply. But there's also theft of tribal property is a federal law. And ARPA has this wonderful provision of incorporating violations of state law into its enforcement mechanism. So there's many opportunities that we can use to help protect cultural heritage, but we have to think outside of the box of just NAGPRA.
Well, let me ask you this. There was one of our chiefs who was very active during the reorganization period, and the Catullas at that time had a copy of the 1859 Constitution written in syllabary, the original Constitution, 1859 in syllabary, and he and Frank Boudinot presented that, plus the flag, the Civil War flag that we have in our collection now. Those two items were taken to Washington, D.C. as proof of who we were and how we had functioned as a tribe. And they left those documents at Washington. I know that because I have a letter from Indian Commissioner in Washington at that time who actually had those things in his possession. And he said, you know, they have this document and we have this flag, and they're both very fragile, but we're wondering to whom we should return them. They're Catullas, and we need to know to whom we should return these items. And I was not able to find the answer to that. But when Levi Gritz's grandson came to the museum and he had the flag, and I knew it was there. We had photos of it in our collection, but we did not know where that flag was. And so he had the flag, and I'm guessing that he also has that Constitution. He does not read the syllabary. And I asked him one time if maybe that Constitution might be. He said, "Oh, we have a lot of syllabary papers. We have just a bunch of them." And I tried to get him to agree to let me come over and let me look at them, let me bring someone with me who is an expert in the syllabary to look at the documents and see what all he had, and he would never consent to that. But I'm wondering whether there would be some sort of legal position we could take to recover those documents. Now, this man has since passed away, and his family, who knows what they're going to do with those things. But you're mentioning about putting a monetary value on things. Some things just don't have a monetary value. They're beyond that. So I just don't know what kind of action we can take to recover those documents. Even if we get a bunch of documents that are not really valuable to us, if they're written in syllabary, we can at least read them and see, whether they are valuable to us. But I don't know how to go about it. Anybody have a suggestion?
I'm trying not to talk. I want to point at Nikki. I want to put her on the spot.
We're being careful lawyers here.
Yeah.
But absolutely, I don't know, depending on where the documents are coming from. So the first issue is where are the documents, who has them, if it's a federal agency or an institution that's been in receipt of federal funds since November 16th, 1990, then there's a potential case to make that they fall under the cultural patrimony definition of NAGPRA. And there are institutions who are defining cultural patrimony under NAGPRA in that way. If they belong to a private individual or an entity that has never received federal money, then NAGPRA is not going to apply. And then it becomes more complicated as to who you're actually dealing with and how to negotiate something reasonable versus making an argument that they're stolen or they're cultural patrimony that you'd need to take to court, which is expensive. We're running close to time, and so I want to stop talking, and I'd really like to pass it on to Ernestine and Nikki for any closing comments or thoughts about how to train your lawyer. Or both of you.
I would just close out by saying, it's, I really do think, if you're the client, just really so important to pay close attention to what your attorney is doing and to feel comfortable with their level of, care for your culture. And their ability to really absorb it in a humble and good way, because some of these things cannot be undone. When lawyers do what they're going to do, sometimes there's no way back. So we have to present really great cases to save our ancestors and our culture. So that is my 2 cents.
Absolutely.
Okay. All right. Well, yes, I agree with Nikki. I think that we need to pay close attention when we are engaging with lawyers, and a lot of the things that you look for are not spoken. In our culture, a lot goes by how you present yourself, what kinds of things that you feel are important, and not just listen to what the lawyers say. Look at who they are, see how they respond to different kinds of situations, and in our culture, I know when I was coming up, there was so much that was just unspoken. It was a look, it was just a little flip of the hand, or it was just, a gesture of some sort that you knew what that meant. You didn't have to ask. And so, like Nikki says, the lawyers must be very sensitive in actually training themselves also in the way that they should interact with the people. And I think that those attorneys or lawyers that watch and listen and learn, maybe not just by asking questions, but you learn by observing and seeing the people and just letting that come into you and absorbing that. I think that is a valuable thing.
Here, Ernestine, thank you. That was beautiful. I want to invite all of you to take a minute and click on the box up there that says polls. It's right next to chats, Q&A, and then polls. If you click on that, you'll see that there's 3 questions that are simple yes or no answers. Instead of bringing them up and taking time to do that, we invite you to go in there and just hit yes or no on those polls for us. We really appreciate it if you could show us some love that way. And I also want to invite you all immediately after this, if you'd like to. I'm going immediately after the session to the lounge. We are going to host kind of a social hour. Pick a table with a subject matter that you think is interesting and take a seat. Even if no one's there, someone will be joining you, and we can have a more informal, smaller discussion about whatever issue you're interested in. I really want to thank Miss Ernestine Berry, Nikki Ducheneaux, and Judith Shapiro for this wonderful and enlightening conversation. I think we need to talk about those lawyers more and make it okay. Realize, demystify that we're not anything that special. We can act as a translator for some things, but really it's tribal sovereignty. It's the tribal client that is the most important entity, person, community in the room. Thanks, everyone.
Everything back.